and then also the history in terms of the initial formation of the organization, as well as the past cases that you might have encountered and solved, and then also the future of the ICC itself, including the challenges that you might encounter and also try to overcome in the future. So without further ado, Professor Jose, the floor is yours.
Thank you very much. Shall I move over there?
Yeah, sure.
Like, where should I stand? You're using the... maybe if you move there, I will not giving you my back. Thank you. Good morning, everybody here in the room. Good morning, everybody joining by Zoom. Thank you very much to the organization for adapting to my request of standing, moving the camera, resetting microphone. It is not my personal whim. Like, I am capricious and I like things in a particular way, like famous singers that have very particular requests for hotels and stuff. No, it is actually to feel closer to the audience, in this case to you. If I sit there, I think we'll feel like some human distance between us, and it is tough to connect. That's the reason I'm standing here, and I asked you to move. I appreciate that you did it. Okay, we are dealing today with the International Criminal Court. That's something very interesting from the point of view of international relations, international law, and I think humanity as a whole. What is your name? Adam. Adam. So Adam, have you ever heard about the International Criminal Court, ICC? Are you familiar with this court? Not so much, not so much. So good thing that you came today. Mm-hmm. The main idea of the International Criminal Court, if we can go to the first slide. Basically is to fight against impunity. Why? This is the first and only permanent international court jurisdiction to prosecute individuals. Meaning, don't worry about the presentation, like you don't need to take picture. No, I can share it with you. I will share it with the department so you can have it, no problem. Anyway, the presentation is not so brilliant. It is only to help my talk to go on with it, but don't worry, you can have it. Meaning, until this court existed, it was enforced in 2002, individuals could not be prosecuted no matter what they did. So they could commit the most terrible crimes, but under international law, only countries were accountable. And in the end, it opened grounds for impunity. Why? Because countries are abstract entities. Countries can do anything. States can do anything alone. They need real people to do things, to take decisions. So in the end, if you punish whatever country for whatever crime, you are punishing the whole society, you are punishing this abstract institution, and actually those who actually committed the crimes, criminals themselves, might be at large, might be free. So that was a big problem. And the court was devised to prevent it, to make people aware before they commit crimes that from then on, if they committed particularly gross crimes, they could not enjoy impunity anymore. Why? Because until the ICC existed, only national courts could prosecute individuals. Meaning, if you are the president, if you're a minister, if you're a prominent person in that country, no one was going to prosecute you because you were in power. So you could enjoy impunity no matter what you did. So the idea of the tribunal is to make sure those criminals could not enjoy impunity anymore. It was established in a fairly late age, if we consider when international law started to come into existence. Okay, for you, because you are young, 1998, 2002 might look like a distant past, but it is not when it comes to international law. And something important to have in mind is that the court can't prosecute people for whatever crimes. Only a very specific kind of crimes can be addressed by the court. Crimes of war against humanity, aggression. When it says against the administration of justice, means when they make whatever obstacle to the functioning of the court, like preventing witnesses to attend the court, not to provide evidence, that kind of things. And something that was added recently, it was not there in the beginning when the court was set, environmental crimes. Let's go to the next slide, please. Let's go a bit to check what the history of this International Criminal Court is. But the first time that it was considered, like people consider, okay, we can prosecute individuals, no matter how important they are, out of their countries, and they committed big crimes, gross crimes. Came after the First World War, particularly the League of Nations even considered the idea of prosecuting the Kaiser of Germany. You know, in the First World War, everybody blamed Germany as the one that started the war and all. So again, the winner country said, if we punish Germany's state of like they did German society, so the state had to pay war compensation. So it means everybody through their taxes had to contribute to pay for something that they actually were not guilty for. Like, okay, our Kaiser or our king decided to go to war, decided to attack other countries, but why should I pay? The only thing I did was to suffer during the war, even to fight during the war. So why I now even have to pay money and not have enough food just because my king took that decision? So for the first time, they considered, what if we prosecute the Kaiser, Wilhelm II? So because of this noise, he ran away, found shelter in the Netherlands to protect himself from being prosecuted. And actually there was not longer noise about it. But for the first time, the idea was around, not to put the blame on societies, on states, but on the responsible people. The first draft about one court that could prosecute individuals came in 1937. The idea of this very seminal project was to prosecute people responsible of crimes of terrorism. But only 13 countries signed, and none of them ratified. So again, it was like one project, one idea. And you see that Second World War was coming in very few years, only. Then something more interesting, the Nuremberg and Tokyo trials. What's your name? Will that. Will that. Will that, okay. Have you ever heard about the Nuremberg and Tokyo trials before? So you are familiar with them. Excellent. What was the idea? After the Second World War, society in general, global society, was shocked by the crime, by the amounts of deaths, destruction. So they said, okay, this can't happen again, and we have to do something with the guilty ones. So they set these courts in Nuremberg and Tokyo ad hoc, meaning, it comes from Latin, they didn't exist before and they will not continue after they finish their work for these particular crimes. So ad hoc, you create this court only to prosecute people related to crimes committed in the Second World War, not in whatever other event, no matter what they did. They had to be committed only during the Second World War. And then when they finished the job, the court will be closed. And it lasted, you see, 1 year after the end of the war, the job was done. There you can see some Germans, some Nazi former officials being prosecuted by these Nuremberg courts. Can we go to the next slide? So there was some problems attached to this trial. Maybe you're familiar, maybe not to this concept, very basic concept in law. Nullum crimen, nulla pena, sine previa lege. What's your name? Arye. You don't know Latin, of course, but maybe you can tell what it means. Nullum crime, nulla pena, sine previa lege. Maybe you can guess, or you can't. Anybody dares? Bold enough to try? No? Okay. Basically says there can be crime if there is no law for that crime. Like they can accuse you of any crime if there is no law saying that that is a crime. They can say, okay, what you did is a crime. Your first question to the police, you are arrested, okay, what are the charges against me, right? It is reasonable. So there need to be a law that made you accountable for what you did. So these Japanese and these Germans that were being prosecuted complained, like, okay, how can you take me to this court if I didn't break any law? You created the law after the crimes were committed. So you can't judge me with retroactivity because when I did it, it was not a crime. You can create the law after the crime, you understand? Maybe after you set the law, from that moment on, you can prosecute people, but not retroactively. So in other words, I didn't break any law. So you can prosecute me if I didn't break any law. Second was the obedience. But they said, actually, I was following the law because when I did what I did, I was part of one state whose laws not only allowed me, but the official legal representatives of the country asked me to do so. So I had the obedience. I have to do it precisely to follow with the authorities, the legal authorities asked me to do according to the law of the country at the moment. So what I did was totally legal. When I did it, it was totally legal. So you can now say that it was illegal later. You can judge me for how things were when the crime was committed. You understand? And a third objection to these ad hoc courts in Tokyo and Nuremberg was the selective nature of those prosecuted. Because either there is justice for all or there is no justice at all. You can apply justice selectively. If you do, there is no justice. It has to apply to everybody to be law, to be legitimate, right? So they said, okay, both Japanese and German accused individuals said, okay, How can you say that we are here prosecuting those responsible for war crimes and crimes against humanity because we want to prevent impunity and you want to punish those who committed them? But here we are only sitting Japanese in Japan and Germans in Germany, the losers. What about the crimes that the winners committed? They drop a nuclear bomb in Hiroshima. They drop another nuclear bomb in Nagasaki, killing civilians. That is forbidden by international law, by customary law. It is not allowed by the Geneva Convention, so you can't do it. But nobody's been prosecuted because of those crimes. Or in Germany, the Allied forces bombed, shelled the city of Dresden. It was full of refugee German civilians. And that's precisely why they bombed that city. And they say, okay, nobody's been accountable for those crimes in Dresden. So it means that this is not justice, because if this court was set to prosecute criminals responsible for war crimes and crimes against humanity, there should also be Americans here. But I don't see any Americans. So if justice is selective, it is not justice, it is punishment. The winner is punishing the loser, but don't call it justice. You understand the principle? Mm-hmm. And what do you think about it, Arif? Do you think they were right? You think they like a strong, convincing reasons to defend themselves or not? I think yes. They had a point, right? They really had a point. But they were so right that, yeah, the powerful, the winner in the end, could do anything they wanted. So they hung those they decided to hang. They sent to prison those they decided to send to prison. So in the end, no matter how reasonable from a legal point of view, the objections were, they were punished. By the way, only few of them were punished. Less than 25 people were pleaded guilty and were either hanged or imprisoned after the trials. So I imagine after World War that all in all, less than 50 people taken together, Germany and Japan were actually punished, meant that was a more cosmetical court, more symbolical court that actually something made to investigate all crimes and prosecute all responsibles, even if we limit it to Japan and Germany. So we go to the next one. Then the Cold War started, and they had a big problem here. When these two courts, both for Germans and Japanese, closed down, even though they punished German and Japanese officials, the international community knew that things had not been done properly. So they knew that the only reasonable thing was to set a permanent international criminal court, not to create ad hoc courts after the crimes were committed. So they knew that the only reasonable legal thing to do was to create one body of law and one court set before the crimes were committed. Because if not, like I told you before, there is no crime and there can be no punishment without law. And you can't always prosecute people retroactively for crimes that didn't exist when the crimes were committed. So in the 1950s, actually there were two projects, two drafted statutes for International Criminal Court, but they were shelved. They were stored and forgotten during the Cold War. Why? Because those who were more likely to commit these crimes, crimes of war, aggression, crimes against humanity, were precisely the Soviet Union and the US. So they refused totally cooperation, and they cut whatever project was on the table to create this international court. Then the Cold War was over after 1991. So people said, oh, finally, there is no Cold War. Finally, this is the chance to set body of law, to set a permanent court, to prosecute individuals and to end impunity. Finally, this is our chance. It was in the air by some legalists, by some intellectuals. Let's say the subject was not down the streets, but it took the streets, it took the attention of people after two particular, after two particular events. One was the war in former Yugoslavia. So in 1993, the international community set another ad hoc, like they did for Nuremberg, in Nuremberg, Kentucky, ad hoc criminal court for the crimes committed only particularly in those wars. There were 4 wars in Slovenia, in Croatia, in Bosnia and Herzegovina, and in Kosovo. So for those 4 wars, this 1993 criminal court has a mandate to investigate and prosecute people. Then, I don't know if you ever heard about the genocide in Rwanda in 1994. You're familiar with it? So they also set another international criminal court ad hoc for it. Why? To fight impunity, and also because times have changed. And now civil society all over the world, even states, were claiming, were demanding justice, not impunity for these crimes when it came to individuals. So let's say both states and civil society demanded, wanted those individuals, those people responsible for these gross crimes to be prosecuted, not to enjoy impunity anymore. So you can see former president of Yugoslavia, then Serbia, Slobodan Milosevic in The Hague, being prosecuted. And people said, finally, even presidents don't have impunity anymore. Finally, these bad guys are sitting down and they have to answer for their crimes. Things are changing. Finally, okay, it is an ad hoc tribunal, but it is better than nothing. This is something unprecedented, something we never saw before, and we hope it also dissuades, prevents other presidents to commit similar crimes. We can go to the next slide. So you can see how big it was in the 1990s and early 2000s, how this president, Slobodan Milosevic, was everywhere, like the face of evil, the ethnic cleanser. I see you in court, like finally we're going to see this kind of criminals in court. So Milosevic was supposed to be the first of a long list of criminals that will be prosecuted. And even though that court, I insist, had only a mandate for crimes committed in these wars in Yugoslavia, things were moving. Can we go to the next slide? And as I told you at the beginning of the presentation, in 1998, the Statute of Rome was passed, and in 2002, it became international law. It came into being, it was owned. So, in theory, the last, all crimes under the scope of the Statute of Rome committed in the last 21 years, since 2002, should have been brought to the court. Things actually were not like that. Okay, some facts about the International Criminal Court. 139 states signed. It is almost 75% approximately of all the states in the world. 108 of them also ratified. It is a bit more than 50% of the states. 4 that had signed and ratified withdrew the ratification, so they were totally part of the court, but they decided to leave it. Two of them, that's why you see the, we call it asterisk. This is an asterisk. So asterisk means that they withdrew, but they decided to come back. So actually, two countries that one day signed and ratified the ICC statute remain out of it. The other two decided to come back. 41 never even signed. What's your name? Sakti. Sakti. What about Indonesia? Did Indonesia sign? Did Indonesia ratify? You don't know. Would you like Indonesia to be part of it? You think it is part of it? You think it's signed and ratified? It didn't even sign? You think it didn't even sign, right? Top marks. Wonderful. Yeah. Like they say in Slobodan Milosevic country, in Serbia, svaka čast, top marks. Muy bien. Yeah. Indonesia never signed, of course, didn't ratify, was never part of it. Curiously, Indonesia was never against it. Indonesia's always said, hey, we think it is a good idea. We are studying it. We might join one day. They have not done it so far. You see other countries like the US that signed very quickly and then decided not to ratify, and they decided even to be out of it. So they were too fast to come into it and also too fast to leave it, saying that it was terrible. Under the George Bush Jr. administration, Secretary of State even said, we have to slay that monster. And the monster was the ICC. So the US wants nothing to do with this court, even though it was part of it, sure. Can we go to the next one? So yeah, here you have a list of the most outstanding absent states, those who are very relevant in international politics, economy, by whatever point of view, but are not part of the Statute of Rome. US, China, India, Indonesia, and Russia. I don't know if you recognize, of course you recognize Vladimir Putin. And last week, the ICC issued a warrant against him. So again, use an example. Wow, now even Vladimir Putin, under normal circumstances, could not be prosecuted because the Russian courts are never going to prosecute him. Now, because of what he's doing, he's subjected to trial. And the person who is below him, do any of you recognize him? He's Mike Pompeo. He was the Secretary of State under Donald Trump's administration. And he said, yeah, the ICC is a thoroughly broken and corrupt body. The US doesn't want to do anything with them. If whatever individual comes to the US to perform any investigation under the International Criminal Court and we find out, we will revoke their visa. We will force that person to leave the US. So we don't want any business with this ICC. Basically, the main concern of these countries are two, except for India and Indonesia. For the other three, because they are big, they are powerful, they are more likely to commit these crimes, and they don't want their nationals to be prosecuted because of these crimes. They also say that it is an acceptable intromission in their internal business. And finally, they suspect that the ACC is not impartial, so they accused it to be set precisely to go against them. We can go to the next slide. So in the end, even the Americans, the Chinese are very concerned about the ICC. In the end, mostly African countries and other, let's say, small ones in the big game of politics are under investigation. There are cases related to them or have been cases related to them. In 21 years, only 52 individuals have been indicted by the ICC. Okay, you can read, but basically, very few people have been prosecuted, very few people have been sentenced, and all of them are from Africa. So here is the fact. After the two ad hoc tribunals for Yugoslavia and for Rwanda, and after 21 years of ICC functioning, only people from the Balkans and from Africa have been punished. So, I don't know. How do you feel about it? It is not fair, right? Like, how is it possible? And even if we think carefully, we say, okay, this is on from 2002. Precisely in 2003, the US invaded Iraq. So it should be a kind of aggression because they are going into a faraway country that was not attacking the US. And what about, I don't know if you're familiar with Guantanamo in Cuba, the military base of Guantanamo, or Abu Ghraib in Iraq, where tortures were performed on prisoners on a daily basis, prisoners who didn't have any clear charges against them. Nobody had been convicted, no Americans had been convicted. Okay, in theory, they can't because the court can only act against nationals of the countries that are part of it, only those who sign and ratify. But it is also true that the court can act if the Security Council, the United Nations Security Council, intervenes. Problem, these countries, the Americans, the Chinese, the Russians are also part of the Security Council. Let's go to the next one. So here we have some conclusions. First, the International Criminal Court is the culmination of a century-old struggle against impunity. So even though we can and we should criticize it, I am a historian myself, so I tend to see things in perspective. We have something better than we had before. Remember, until the end of the 20th century, we didn't have any way to prosecute individuals. So now we have something. We advanced. We didn't reach the goal yet, but this is a step on the right direction. So by criticizing it, we could lose all we have won. So I think it is important to think in perspective and to tell ourselves, okay, if we are really committed to fight against impunity, we are moving towards on the right direction, and we have to go on moving in that direction. Instead of saying, hey, this is not working, it's only for Africans and Slavs, like Russian and Balkanians, so let's close it down. Also, it reflects the same limits that the UN system suffers from, meaning, you know that the United Nations system could only be enforced because of the guarantees, the privilege that these 5 countries, the winner of the Second World War, have. So it was a very tough choice. Either we don't have any international community, any United Nations, it could be bad, or we give some powerful countries a special privileged status, but goes against the spirit of the UN. But the alternative is not having UN. So this is a very complicated crossroad. Same happens for the court. It is better not to have any court at all. No, it is important that individuals can enjoy impunity anymore. But is the court what it was supposed to be? Universal? Because again, if there is no justice for all, there is no justice at all. And also another lesson is that sentences alone do not bring about peace, justice, reconciliation, reparation, and truth. Meaning, you can prosecute, you can punish people who actually committed crimes of genocide, aggression, crimes against humanity, but unfortunately, sentences alone sometimes even make things worse. And here, okay, do you recognize the person on top in that picture? It is the president of Sudan. He was supposed to be in prison because the International Criminal Court decided he was guilty, sentenced him to go to jail. But you see, how in his country, everybody loves him. And they say, hey, we are not giving him, handing him to the International Criminal Court. And he travels all over Africa and nobody arrests him. Even countries that signed and ratified the Statute of Rome. Why? Because hey, it is not fair that this person goes to jail. Even though, again, that court with evidence, with judges, have decided that he is guilty. And then you have General Mladic from the Balkan Wars. He was convicted for a number of crimes. One of them was the killing in cold blood of 8,000 people on the spot. So after that, you can say, okay, this guy is really bad. I mean, you can kill 8,000 people in cold blood on the spot and just pretend that nothing happened. So after many years, he was finally arrested. He finally went to jail. But you see how some local papers reacted to it. This is Mladic is a Serbian hero. They have no problem on burning it down on the cover of the newspapers. Did you walk around the Serbian regions of the Balkans? You'll see plenty of graffiti saying General Mladic is our hero. It also applied to the other countries. You take that Balkan example. So people, let's say Croats fighting Serbs. After the war, everybody wants justice. If one Serb goes to jail, the Croats celebrate and say, hey, finally, we have justice. Finally, this monster is in jail because he did this and he did this. But if the court prosecutes and punishes one Croat, the same Croats that were celebrating that justice was done for the Serbs don't accept it. Say, no, he's a good guy. It was war. What he did, he had to do. He did it to protect the nation. So it is unfair that he's prosecuted. So in few words, we like justice to be applied to our adversaries, to our enemies. And then we say that's something well done. When it applies to us, to our people, we always find ways to criticize it. And people even gathered in the streets and protest very fiercely against the sentences to Croats, Serbs, or Bosniaks, in this case, depending on who was sentenced to jail, because there is no death penalty in this International Criminal Court for former Yugoslavia. So, few words, you have this initiative to prevent impunity, who had all sense in the world to exist, because the crimes we're talking about, genocide, aggression, crimes against humanity, are very serious. But you see how in real life, things are more complicated. Okay, I wanted to open the question to you precisely because last week, President Vladimir Putin was issued that arrest warrant against him. Many people in the world said, okay, finally, you see that things are done in the right way. I wanted to put it in context and to make you think a bit and to be aware of what it means. And also to think as Indonesians, where would you like Indonesia to be in this game? So thank you very much for your patience, for your attention. And this is what I wanted to tell you this morning. And of course, I'll be super glad to hear your questions, comments, or objections. Why not?
Okay, for anyone who would like to ask any questions in the room, or perhaps the people who are in the Zoom room, you may ask to the professor.
And also pass the microphone in the room so the people in the Zoom can hear them.
Ya, Pak. Tes. Assalamualaikum warahmatullahi wabarakatuh. Let me introduce myself. My name is Gana Sakti Maharashtra from batch 2022 from the class of International Law, class K. So my question to you is, since you explained about the ICC and stuff, the question that's bothering my mind is, why hasn't the ICC issued an arrest warrant against political figures like George Bush for his involvement in the Iraqi invasion? So that's my question.
Very good question. If we look at common sense and if we look at the Rome Statute, it was a clear crime of aggression, also crimes of war, and even crimes against humanity. So George Bush could have been prosecuted under those crimes. Problems. First, can we go back to the presentation? Is it possible? Can we go after the last one? Later, to the very end. Later. No, you are going back. Like, go forward. Yes. Forward. To the very end. Oh, I prepared some because I knew you were going to ask that question. And I prepared one cartoon dealing with it. But apparently in the end I didn't include it. I don't know how. Every day I find out how clumsy I am, not even making a PowerPoint presentation, but okay. The cartoon showed the ICC, like one table with judges and all, saying to the US, like you said, okay, you did this. Why don't you cooperate? Why don't you do anything about it? And then this is like the table where they are, and then the US is in a much bigger one, say, because I'm big and strong. But that is the main reason, like in real life, but there is something else. The US withdraw the signature, of course, never ratified, so it is not part of it. So the court cannot act against citizens of countries who are not part of the ICC system. So as the US is not part of it, US citizens can do anything they want, that only their internal courts can prosecute them so far. So this is a legal question about the mandate. The ICC legally can't prosecute any Americans, any Chinese, any Indonesians, because you are not part of the system. And it is write it down. This statute of Rome only applies to nationals of the countries who are part of it. So that is the reason. But I insist, main reason is not legal, because in this case, there is a legal base for the Americans not to be prosecuted. But even when it is, they could do whatever because they're strong. Okay, you are students of international relations, most of you. So you know that is the big rule in the end. The big lion takes everything. Bawan.
Thank you very much. Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Rizky Asti, and I would like to ask Mr. Angel regarding the ICCF, especially their reputation for an unfair and unjust prosecution towards a nation that essentially for developing underdeveloped nations, such as the nation that you already shown us, 10 African countries or countries that are currently having internal issues such as civil war in Myanmar, Afghanistan, etc., etc. And I'm wonder, does this trend of picking nations that are not essentially a Western nations, are the way they make this decision, their mindset of these decisions, is there any justification that they always make, especially, and what are the reasons, for example, for especially a Western nation conduct something that are questionable in international law, but not are being prosecuted? For example, UK have a lot of big history of let's say crime against humanity, but it was before the ICCF. But my biggest question is that, is there a chance for the ICC to reform itself as a better organization, so that maybe in the future they have the power to prosecute this nation that are essentially influential in the ICC, that they still have the power to prosecute Western nations, especially an individual from Western nations? Do you think that ICC will have that future, sir? That is my question.
Thank you very much, Bawan. I ask myself that question permanently. It is a very good question. First, dealing with crimes committed by individuals belonging to Western countries. When accusations like that have been addressed to the ICC will say, no, this criticism is unfair. We fight against these crimes no matter who commits them. So just by chance, just because it is the way things have come, yeah, it is mostly about African countries, and so far only Africans have been sentenced. But we are open to anything. We don't discriminate at all. That's what they say to defend themselves. But yes, still there is something fishy, something smells here. So yeah, reform is necessary. And I like your concept because you said reform and mindset. And I think there are two very interesting points to think about this question. Reform, because if we conclude that the ICC is not doing its job, it is very expensive. They spent $1,000 million only to prosecute and to sentence 6 Africans in 21 years. Say, okay, this is not working. Let's close it down. This is one way to look at things. But we'll be back to the starting point of impunity. So yeah, we should improve it. Yeah, it is flawed yet, but let's improve it. Let's not close it down. Problem is how to reform it. And here comes another question. Same problem that we have at reforming the United Nations. Because since I was a kid, and yeah, we have to make a deep reform of the United Nations. It reflects how things were in 1945. We are not in 1945 anymore. How is it possible that countries like France is a permanent member of the Security Council, or Germany is not, Japan is not, only because they lost the Second World War? This should be changed. It is common sense, but it is not changing, and it is not going to be changed tomorrow. So yeah, reforms are necessary. because both the UN and the ACC are steps on the right direction for humanity, but reforms are very tough to implement. And how to do it? If I knew, I would not be here. I guess I'd be in Geneva or in UN headquarters in New York. But it doesn't mean I don't care. Yeah, it's something that sometimes I can't sleep because of this thing, because I don't see the way out. I see, like you see, like millions of people see what should be done when we can find a way to do it. And yeah, there are some scholars that wrote articles, journalists, politicians, lawyers, making proposals, but none of them have been so far influential or taken seriously. So yeah, we are facing these structural flaws, both in international law, even when it comes to individuals like the ACC and the UN system as a whole. Because if the countries who are more likely to commit crimes, because they are the more powerful, can protect themselves because of the veto right of the Security Council, the game is rigged. And you can play any game and you don't play with the same rules. And the powerful even have advantage. I mean, you play football against bigger, stronger players, and they even can do things you're not allowed to do. It will not be a fair game by no means. You can't win that game. Thank you for your question, Bob. Well,
Okay, Professor, there's actually one question from the Zoom room, and it's from Khalid Abdullah. He is asking, in your opinion, does Indonesia or any other countries who didn't ratify as a part of the ICC, could they pose a future challenge or danger to the international security? Thank you.
so the first part of the question is about Indonesia. The second one?
Yeah, it's about, in your opinion, does Indonesia or any other countries who didn't ratify the ICC, could they pose a challenge or pose as a danger to international security?
No, I think danger is not the word, but they make it weaker. Like if the ACC can't count on China, on the US, on Indonesia, India, most of the world population is not subjected to it. So it means it's not what it was supposed to be, because again, either there is justice for all or there is no justice at all. Justice can be selective, like, okay, depending on the country you belong to, you can be prosecuted for this crime or not. That is not justice. I think Indonesia is one of the countries that can play a big role because it is big. It is getting bigger every day. And what Indonesia says might inspire others to follow as an example. And I think you are seeing, as because of this long tradition of neutrality through the non-aligned movement, you are still leading country. The movement is now weak, but still exists. So you have this tradition of neutrality, of soft power, and your voice is heard with more and more respect in the world. So yeah, I think Indonesia is one of the countries that are clean, like doesn't have ugly past issues concerning other country that you made attacks to or anything. This East Timor was a big deal 24 years ago, but let's say it was something minor. So I hope people like you in the future study, work on international relations, international law, can stand and make a difference and contribute with ideas to improve what, like Bowen said, really seriously needs to be improved.
Okay, is there any other questions from the audience?
Yeah, thank you very much. So my another question. So a couple of months ago, maybe a couple of weeks ago, ICC have declared that they declare Putin to be arrested by the ICC. And I'm wondering what is the power of ICC when they declare that? What kind of power, what kind of ability for ICC to demand such a thing? And since Russia is not part of the ICC, how can ICC demand that kind of prosecution towards a nation that are not part of their members? And I'm wondering, and this is just a scenario, if in the future, who is lost between the Ukraine or in Russia? Let's say Russia lost in the war, hopefully, hopefully. And is that the opportunity for ICC to demand the arrest of Vladimir Putin by the ICC? Do you think that is like one of the big opportunity for ICC to demand that? Or if, for example, Russia won the war and ICC still demanded, do you think that ICC will have any chance in that scenario, sir? That's my question. Two questions.
Again, you raise something very interesting. First, if Russia never ratified and never withdrew the signature in 2016, in theory, the court could not issue any warrant against him, like we said before. If we can prosecute George Bush Jr. because of the war in Iraq, for instance, because the US is not part of the system, why can we do it with Vladimir Putin? So again, it looks like the court is biased. And second, what power the ACC has? In theory, the court is piling up evidence, so they have enough evidence concerning kinds of war and crimes against humanity committed by Vladimir Putin. So in theory, if he goes to any country, part of the system, he could be arrested and brought to the court. If he comes to Indonesia, he's not going to be arrested. If from Russia to Indonesia, because you have no business with the ICC. If he came to Spain, to my country, he might be arrested because of the warrant issued against him. On the other hand, the other legal way to prosecute him was if the Security Council intervened, saying, okay, even though this country is not part of the system, if the Security Council approves it, that national from that country can be prosecuted. But Russia is part also of the Security Council, permanent member, so he can also veto it. So in theory, there is no legal basis to catch Putin. So this warrant against him, to me, I have to go deeper, because as far as things are so far explained, he's in the same situation like George Bush Jr. Country is not part of the system, so he can be prosecuted. And the Security Council can't do anything if Vladimir Putin himself doesn't allow it. So yeah, we have a big contradiction here, and it looks like very political. Like it reinforces the criticism that the ICC is pro-Western, because now Vladimir Putin is like #1 public enemy of the West, and suddenly the International Criminal Court goes against him. So it deprives him of legitimacy, saying, okay, see how bad he is, that this International Criminal Court, who is something legal, is something impartial, goes against him because he's the bad guy. But why didn't happen to George Bush, for instance? So yeah, I think there is more politics than international law involved here. That's what I see. Not very well thought about. What else?
Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad William Safitra. I want to ask you something. In the slide and the presentation and the question from him is about Russia, but I want to ask you about, is the ICC ignoring the conflict in Israel and Palestine, because Israel also commit crime in Palestine. But the ICC, if I look at it, is really ignore their conflict. So what do you think about that?
Yeah, another case that worry many Indonesians. Israel also refused to be part of the ICC. So it means that Israeli nationals can be prosecuted by the ICC unless the UN Security Council decided that they should be prosecuted, these Israeli nationals. But as long as the US, let's say, protects them, there is no way to act, at least from the ICC. So there might be another ways to intervene. The ICC is not the only way that the international community can exert pressure on Israel or try to do things. But we go to the letter, as they are not part of the ICC system, Israeli nationals are not under the umbrella, they are not subjected to the ICC statute. So the mandate of the statute doesn't affect Israeli nationals. So as for today, few words, Israeli nationals can be prosecuted by the ICC. In theory, only Israeli courts can prosecute them. On whatever sentence they have is all they can have. Of course, what is in your heart and mind, is it fair? Is it not fair? Probably it is not. So again, it is tough to adapt law to what common sense says it is fair. Because here we are not even on the page of having our sympathies here and there, but even if we think of on common sense terms, many things just don't fit here.
Is there any other questions from the audience?
Room is also quiet. Zoom room. All right. So again, thank you very much. Muchísimas gracias for your time and attention. It's been my pleasure. Today are my last lectures.
Sir,
Yeah,
there's someone who would like to ask something from the Zoom room.
fantastic. It's never too late.
Widya, would you like to ask a question? Okay, I think she just accidentally opened her mic. So yeah, would you like to say any other additions, sir?
No, I was just saying that now that I'm getting used to come to the campus to lecture here, I'm going to miss interacting with you. Why? Because you see things differently. Like sometimes when you're in a country or in a continent, we are like some social agreements. Everybody sees things in the same way. So sometimes fresh eyes, fresh ideas really challenge what you think. It goes both ways. So for me, it is extremely stimulant to be here, to listen to you. And yeah, I'm going to miss it. I hope I'll come back one day and I keep on lecturing and talking to professor and students here for a longer time. You're free. You might go in peace, like Christian priest say at the end of Mass. You can go in peace.
Okay, let's give Professor a round of applause. So if we have no more questions, we may as well end the session. Thank you so much, everyone, for your attendance in this lecture, and also Professor for delivering such insightful material. I hope everyone will have a great rest of the day, and Assalamualaikum warahmatullahi wabarakatuh.
One more thing.
Oh,
Sorry, we already closed, but just to tell you that I'm here for the rest of the week. Normally, I'm at the International Relations Department, so if you want to come to talk, visit, ask anything you want, I'm at your service. Come with confidence, come relaxed. It'd be my pleasure to see you, okay? I'm at your service.
Thank you, sir.